I'm Gerard McDermott from Outer Temple Chambers, native Mancunian. For those who aren't from Manchester, welcome to our city, which just gets better and better. And welcome to those who've been before to what Carin Hunt and I think is probably our fifth, if not our sixth, annual travel law seminar in Manchester. We've got a really good selection of speakers, and thank you particularly for those who aren't from Outer Temple Chambers who've come along to help us this afternoon. I'm going to chair proceedings, which means I don't really have to do anything at all. Capture a bit of limelight, get a few pictures for Twitter or Insta. For those who don't know, I'm trying my Insta game. Not quite onto TikTok. I'm not quite onto TikTok yet. I need to train the cat to do a few more tricks for that. Without further ado, I'm going to ask our first panelist to speak. So you're going to hear from Carin Hunt, who's one of our brightest juniors at Outer Temple. She specialises in PI, clinical negligence, travel law, inquests, professional regulation, court protection, educational law, and the law of international organisations. If I just pause for a moment, I'm really pleased to see that, because there's a temptation to specialise too much at the bar sometimes early on, and the wider practice you've got, the better the experience that you've got to carry across the various disciplines. But it's always a treat to hear from Carin. I used to introduce her with a joke, then I realised she was funnier than I am. Carin, welcome. And Nathaniel Martindale. Nathaniel, thank you for coming to help us today. Nathaniel's an associate solicitor at Irwin's within their international serious injury team, based in Manchester, a renowned team, of course, and his practice includes English claims under the package travel regulations, applicable law, jurisdictional cases, and they're going to talk about force majeure, acts of God, and disasters. And I'm just going to sit and learn. I don't know which of you is going to speak first, or perhaps you're going to speak together. Carin.
Hey, thank you, Gerard, for just setting me up to fail there with whatever jokes I produce. I'm just having a bit of trouble getting my slide up. Chris, we see in the room. There we are. Okay. Yes, so welcome. Thank you very much, Gerard, for that introduction. We are going to talk to you about force majeure and package travel. This slide I've tried to make really exciting, this volcano and these little COVIDs. It is the height of the excitement in this talk. I will be taking you through the regulations in detail in just a moment, so enjoy it, because it's all downhill from here. Bye, Joe. So what are we going to be talking about? Okay, I think my clicker isn't working, so I'm just going to demonstratively click each time I need. Yeah, there we go. Okay, so what are we going to talk about? We'll very briefly talk about sort of the force majeure concept. I'll take you through just the relevant provisions of the regulations that you'd want to know about when dealing with force majeure type circumstances. Nathaniel will then whiz you through some very exciting domestic case law that looks at how these provisions apply in practice and are dealt with by the courts. And then I will take you through some CJEU case law that the courts may or may not choose to follow in these exciting post-Brexit times. So yes, firstly, and good news, we don't really need to worry about this slide, because the force majeure concept within the regulations sort of operates in and of itself. It's a standalone sort of provision and way of looking at things, so you don't need to know about the sort of English rule of force majeure or lack thereof, really. And you really just need to focus on the regulations themselves. And we'll come to an EU case that very much emphasises that idea that the force majeure concept is all contained within the regulation, and force majeure cannot be applied on top of it and beyond what those regulations say. So in that case, the regulations, that's not my slide. Oh dear. Okay, the regulations are where we unfortunately must start. So I'm just going to whiz you through those to sort of highlight what's relevant when we're looking at this idea of force majeure. But the general idea is something unexpected and extraordinary has happened. you either get out of some kind of requirement of the regulation because of that, or you're entitled to something you wouldn't ordinarily be entitled to because of that. And so there's a few regulations that are relevant, and we shall whiz through those now. So the first one is Regulation 16, which we are probably all familiar with anyway, because in combination with Reg 15.2, it's what we use to ground our claims of, injuries on holidays straightforwardly. But it also contains, firstly, this provision entitling the traveller to a price reduction when there's any lack of conformity in the contract. Lack of conformity being regulation speak for improper performance or failure to perform the contract. And the only get out for that is that it's the traveller's own fault that there is improper performance of the contract. So that is not strictly a force majeure type scenario. That's any lack of conformity for any reason. And one of the EU cases we'll look at later emphasises that point. But we do get the relevance of force majeure type circumstances when we look at subsection 3 of Regulation 16. Because it provides an entitlement to compensation for damages caused by a lack of conformity, but there's a get out for the organiser, which is, amongst other things, where the lack of conformity, so the failure to properly perform the package, is due to these unavoidable and extraordinary circumstances. And that's the terminology that the regulations almost 100% use for dealing with force majeure type circumstances. I'll come to the definition of it in a moment. But yes, that is the first way in which extraordinary circumstances change what the traveller is entitled to and what the organiser is required to provide. Okay, and it's worth noting for anyone operating in the injury specific field that that's the limit of how an organiser can limit their liability for injuries. You can't go on beyond sub 4 there. So that's the area that you're probably all familiar with. This is the area that got a lot of traction during COVID, but was sort of slightly less interesting to those of us in this field beforehand. This is essentially the entitlement to refunds allowed for under the regulations. And there's 3 regulations in particular to look at, Regulation 11, 12 and 13. Regulation 11, the gist of the force majeure element of this regulation is that where the organiser is constrained by circumstances beyond its control to alter significantly any of the main characteristics of the travel services contracted for, and travel services being, the big 3: accommodation, accommodation, transport, or rental of motor vehicles, then the organiser has to tell the traveller about that, offer a price reduction if those changes make the package less valuable, or offer the traveller the option to terminate the package with no termination fee payable. The traveller is always entitled to terminate the package, but liable to a termination fee. But if these circumstances persist, that is, circumstances that significantly alter the package and were not within the control of the organiser, then the termination fee is waived and the contract just gets cancelled if that's what the traveller chooses. Regulation 11, when we come to look at regulations 12 and 13, will begin to stand out because it doesn't use the phrasing of unavoidable and extraordinary circumstances that the rest of the sort of force majeure provisions in the regulations use. It only uses one part of that, which is the idea that something is outside of the control of the organiser. So that's the first thing to note. And secondly, it also describes the consequences caused by whatever these force majeure circumstances are differently to how they're described in regulations 12 and 13, because they're in relation to Schedule 1, which really relates to the information provisions of the details that travellers are entitled to know about the travel services they've contracted for. So it just stands out slightly differently from those and means that cases interpreting 12 and 13 won't necessarily map on directly to Regulation 11. It will all become a bit more clear when we look at 12 and 13, because you'll see how those are differently drafted. So Regulation 12 relates to the traveller's entitlement to cancel the package at any time. And as I said, they can do that at any time, but they'll have to pay a termination fee unless they fall within subsection 7 and 8, which is where there are unavoidable and extraordinary circumstances occurring at the place of destination or its immediate vicinity, and which significantly affect the performance of the package or the carriage of the passengers to the destination. Then the traveller can terminate and doesn't have to pay a termination fee. The traveller will not be entitled to compensation if that is the case. So a few things to just note about the operation of 12.7 and 8. Firstly, the relevant circumstances, the force majeure circumstances, the unavoidable and extraordinary circumstances, have to be at the place of destination, according to this regulation, rather than the place of departure, which could perhaps create something of a lacuna and difficulty for consumers in certain circumstances. Although sub B relating to the carriage of passengers is probably the biggest point that would arise from something going on at the place of destination that would affect an ability to get to the package. There's also likely to maybe be some question over, what constitutes the destination and its immediate vicinity. What if you are travelling to one particular area, but part of your plan was to travel to different areas which are affected? That might be something that comes up when looking at the entitlement. So I think that's worth noting. It's also worth noting that the way it's phrased, and particularly the fact that it's phrased in the present, so these circumstances are occurring at the place of destination, means if this comes to court and there's a question over, well, were these circumstances occurring and did they significantly alter the performance of the package? Well, how is that going to be proven, and sort of what test or standard of proof will apply? Will it be, well, that's just a fact that you have to prove on the balance of probabilities, which will be a relatively easy test? Or will it be, well, actually, we think that this is a much stricter provision that really requires a stricter proof of, the circumstances in place at the time absolutely would have stopped the package being performed sort of to its full 100%. So that's, I think, also something that is left to the imagination at the moment in the drafting of the regulation. Another thing is, it's also clear that the traveller can cancel or terminate before the start of the holiday, but how close before the start of the holiday? Because obviously, again, going back to that present tense occurring, it seems that you need to be sure that those circumstances are perhaps going to be continuing to occur up until the time the holiday would have taken place. So again, that creates a bit of a question mark and perhaps a certainty issue for situations where it's unclear when they will be resolved. There's also the point, I think, to be made that there's no additional compensation that the traveller is entitled to. And one can foresee very easily where the need to cancel a package travel contract will have indirect expenses to the traveller who's perhaps booked excursions or other elements of their holiday not through the package, and they'll lose out on that basis. So I think that provision not allowing compensation is sort of striking the balance between the high protection of the consumer that these regulations seek to enforce, but also keeping kind of the solvency of the travel industry at play as well. So I think that's where the balance is struck there. Moving then to Regulation 13, which is kind of the reverse of Regulation 12. It's the organiser's ability to cancel the package when there are these extraordinary circumstances. But it's worded slightly differently here, because the organiser can only terminate the package when the organiser will be prevented from performing the contract. So not that the contract will be significantly altered, as under Regulation 12, but instead that they'll be prevented from performing the contract. So seems to be a much higher threshold from the decision to word it differently. I think the reason for that is because Regulation 11 that we looked at is the one that deals with an organiser faced with needing to alter the terms of the contract, but still being able to carry them on. So 11 and 13 go to the organiser's entitlements to change or cancel. Regulation 12 looks different because there's only one provision for both scenarios. That's why it's worded slightly differently, but it's always important to read 13 along with 11 when, particularly from the organiser's perspective, what can I do if these unavoidable and extraordinary circumstances have arisen? And then finally, and importantly, when coming to refunds that you are entitled to under 11, 12 and 13, there's a provision that they have to be paid without undue delay, which is the wording of the directive, and then we've added in England and Wales, not later than 14 days after the package travel contract is terminated. So a very tight work turnaround for those refunds, which I think we saw in COVID caused some difficulties for the industry. And then, of course, very important is that unavoidable and extraordinary circumstances are, unlike many of the terms used in the regulations, defined in the definition section. And you'll see here that we have the two elements, that the circumstances are beyond the control of the party seeking to rely on them, so usually the organiser, and also the consequences of the circumstances couldn't have been avoided even if all reasonable measures had been taken. And we also saw how in Regulation 11, only the first limb of that definition is what's required for it to be invoked. So those are sort of how it's defined, but very helpfully, if you go back to the directive which the regulation seeks to implement, Recital 31 gives some examples of what these extraordinary circumstances will be. So helps to sort of put that into practice. Obviously, for COVID, a significant point was outbreak of a serious disease, but there's other examples there of natural disasters. That's why you have the Iceland volcano on your first and exciting slide, and also warfare. So that's a very helpful slide to look at, but it's not exhaustive and it won't constrain things, but you'd like to use that to sort of purposefully argue that whatever circumstances you're talking about are similar to these in some sort of material ways. So that is a whiz through the exciting black letter law of the regulations. Happy to chat through them at the break. I've got a physical copy here with me if anyone would like to take a look. But for now, Nathaniel will put some of that into practice and look at how it's actually been applied in the courts.
Thank you, Carin. To start with, Carin introduced the case as exciting. I'm not quite sure I'd go that far. I'll try and put as much light into them as possible. And obviously, we could have chosen the clicker.
Oh yes,
a bit of persuasive for me.
I think you have to. I think yeah, pick up Vicky, and she's actually doing it.
Right. Okay.
We have people perform the functions of our machines.
GCSE grammar is coming into effect finally. We could, of course, have chosen something really exciting like the volcano or the fires in Greece, but sadly, I'm taking you back to COVID, so apologies for that in advance. It's all too familiar and obviously something we'd rather forget. But what I'd like to do is kind of put some skin on the bone, so to speak, of what Regulation 12.7 actually looks like in practice, and 13. And obviously it goes without saying, really, but it was significant time for travellers, tour operators and insurers in terms of how they were all dealing with this. Unprecedented comes to mind, as if we've not heard that, I know. And Carin already mentioned about the fact that there's this requirement on tour operators to process refunds within 14 days. You know, the issue with COVID, of course, is that it was so fast-paced and so moving and different. There was a time when we couldn't literally leave our local areas, and there was a time we could go out but not travel. So the way that tour operators were approaching this literally was changing kind of week by week. What was the FCDO saying, for example? Every country was dealt with differently. Some countries weren't allowing Brits or any other foreign nationals into the countries, like Israel for a long time, for example. So it really was a very tough time, I think. I'm a claimant lawyer, so claimants don't be me, but it was a tough time for the tour operators in terms of how they could deal with this. Okay. Good. I think what is quite useful to go back and start with is just looking at a case called Lambert and Travelsphere, and it draws some similarities to the situation with COVID because it actually related to the outbreak of the SARS pandemic in China and Hong Kong in 2003. And this package was actually subject to the old package travel regulations, but it obviously was in a similar vein in terms of the issues. And in this case, it was actually the travellers who made the decision to cancel for fear of obviously going to this holiday and contracting SARS. And effectively, the tour operator refused to kind of make payment. The Lamberts pursued a claim in relation to those cancellation charges. And as it actually happened, I believe that the package was cancelled in any event. But the issue was whether or not the tour operator was required to provide a refund at a time when it wasn't sure or wasn't clear whether or not the package could go ahead. And effectively what the case established was this kind of flicker of hope test, so to speak. I'm sure many of us will have heard of this since the outbreak of the pandemic. And effectively what that means in practice is, did the tour operators have a flicker of hope that the holiday could still proceed? And at what point really does that crystallise? When does the tour operator or when does the traveller realise that's no longer possible? I can see a few faces in the room of people who have used this flicker of hope defence quite a few times in terms of when their claims were being pursued. But it was effectively the way that it was dealt with at the time. There wasn't really a great deal of guidance around this issue. And it kind of goes back and re-engages this concept of unavoidable and extraordinary circumstances. It's really important to break down unavoidable and extraordinary occurring at the place of destination or its immediate vicinity. Carin kind of touched on this already, and there's a lot of analysis about each strand of those particular words, you know, what was happening when, at what place, what was happening at the destination, at home, etc. And I think it's useful to, in this case in Lambert Travel Sphere, the decision actually was that the claimant was entitled to a refund, notwithstanding the fact that the package was eventually cancelled. They had cancelled at the point when there was a flicker of hope, actually, that the package could have gone ahead, and therefore they weren't entitled to do that. I'm used to this. And then just looking at some kind of other cases, there were a couple of unreported cases at the time that were quite interesting, just in terms of how the courts were approaching this issue in a practical way, just like us, who, let's be honest, basically had no idea how things would be dealt with. There were some really interesting and unusual decisions from the courts, some which were kind of very consumer friendly, some which were very tour operator friendly. And this one was interesting because Mr. Braithwaite cancelled a package claim with the holidays. This was an unreported decision from Clerkenwell County Court. And at that time, and as with many people who were travelling, there was an FCDO advisory against all but essential travel. And Mr. Braithwaite took that as his kind of carte blanche to cancel the trip, essentially. Love Holidays didn't provide a full refund for their trip. I think that I've actually provided most of it, but effectively they said actually the FCDO advice doesn't actually amount to the kind of circumstances as would be imagined by the package travel regulations, these unavoidable and extraordinary circumstances. And effectively it was argued by the defendant that it just wasn't going to be a case where they would be able to take a refund. And Mr. Braithwaite sought a refund for that cancellation. Actually, the judge found that the FCDO advice did amount to unavoidable extraordinary circumstances. And I think at the time when the decision came out, when there was when it was publicised, there was a bit of concern, you know, from tour operators, because attaching that label effectively to the FCDO advisory became quite dangerous. You know, was it the kind of open letter for travellers to cancel all their trips because of the FCDO advisories, which were changing daily, country by country. And there was a question, I think, in most people's minds, about whether that actually could be considered the right decision. Because actually, when you think about it, it doesn't necessarily think about the place of destination or its immediate vicinity. You know, there was a case I had, for example, where it was a trip to Iceland, and it was very early doors in COVID. Everything went ahead, and the number of people who had COVID in Iceland was about 15, 20 people. You know, they really did well at kind of trying to contain it as much as possible. So I guess the issue with a decision like this is, does it really properly engage the regulations in the way that they kind of anticipated? Another case is Brimley Foundation School and Hollywood International Travel Limited. And actually this was a commercial organisation, essentially. It was a school who had booked a ski trip to the US. An unreported decision from Cardiff County Court from 2021. And it was due to depart on the 2nd of April 2020. Cast your minds back to that point. a point when really we couldn't leave our own areas or houses without going too far without a very, very essential reason. So the school took it upon themselves to cancel the trip, sought a refund from the tour operator. And again, the defendant in this case had argued that a refund wasn't required because the claimant had cancelled, and there was no impact in relation to the destination because there was a local factors impact, and effectively the judge said the claimant took it upon themselves to do that. Again, just taking your mind back, I think between March and June 2020, we were not actually able to leave the house, and that's for essential reasons. I think it was even kind of the risk of the police becoming involved in those very early days. And there's no way it would be possible for us to left the country. It couldn't be considered an essential reason, if nothing else. I did stumble across a very interesting document called Coronavirus, A History of English Lockdown Laws. So if you want some bedtime reading, can I please recommend that? And if you would like the link, I'll be very happy to send it to you. But, in this case, I think the judge took quite a reasonable stance and said, hold on, really, the claimant is entitled to a refund. It's clear this comes to the carriage of passengers, significantly affected both in the UK and the USA. I think if I'm right, the USA weren't allowing international travels at that time in any event. So there was no possible way that this package could have gone ahead. The next case, again, unreported from Lincoln County Court, seems to me to be more within the spirit of what the package travel regulations are trying to say or trying to achieve. This was a lady who booked a holiday which is due to take place during the pandemic. Again, because of the change in rules and regulations, you might recall there's a time where if you fancied a foreign trip, great, off you go, but you're going to have to come back and quarantine in a hotel for 2 weeks. You're going to get a £1,500 bill for that, and that's kind of the situation that you're in if you want to go away. And Ms. Dennison decided to cancel the holiday on that basis, that she would have to quarantine on her return. And she sought a refund from the holidays. The holidays who actually refunded all the monies except for the flights, on the basis that the flight had actually operate. And they argued that the package could actually have been performed in the way that it was envisaged it would be performed. So it was held that because the package could be performed in this case, the claimant wasn't actually entitled to a refund. There was a significant impact and there was no breach, basically. These are just kind of some other examples of kind of the unusual stances that people were taking during COVID, and probably to be fair, because people didn't really know what they were doing. But for example, there was a case that I saw where a client had booked a package holiday and a cruise. Cruises essentially right in the middle of the package holiday in Canada, and the cruise itself was cancelled, but not the package holiday. The client sought to cancel that and sought a refund, but the defendant then denied it on the basis that the package could go ahead. In actual fact, there was no way it could go ahead because in Canada at that time, there was a total ban on foreign nationals entering the country until, I think, June at that stage. And again, you're kind of thinking about all the elements of unavoidable and extraordinary circumstances at the place of destination or affecting carriage. In this case, every single one of those issues was kind of ticked from our perspective, but the defendant was taking a hardline approach. There was another case we had where the claimant had been advised by a GP that it'd be highly susceptible to becoming very unwell if you contracted coronavirus, and cancelled about 4 months before it was due to take place. Again, on the opposite side, it would be really hard to say, applying the flicker of hope test, that he couldn't have gone ahead. There may well have been no restrictions, limited restrictions, or even not that much presence of COVID on a particular Greek island at that time, for example. There was also quite a lot of issues in terms of curtailment cases. So people who had already set off on holiday, there was one in mind where a chap and his family got to Mauritius for a really luxury holiday for about £50,000. And halfway through, tour operator said, "I'm really sorry, but you're going to have to come back." He was like, "I don't think so." Get £50,000, as you can quite imagine his distress. And put his feet up on the beach and didn't bother getting on a flight. Eventually, he had to come back because Mauritius closed their airport, and there would have been no way for him to have left the country. FCDO advisory was saying you shouldn't travel to Mauritius, etc., and so on. And the issue with that case became about what level of entitlement of refund was the consumer entitled to. And obviously with a package case, you get an overall price. There's no breakdown. It's done like that for a reason. And it becomes quite difficult to determine to what extent some funds may have been paid or not and what refund they might be entitled to. So there's obviously a scrap over that, but there was an element which would have been refundable for the accommodation not used, for example. And then there was a really bizarre case where we had a guy who was going on a skiing holiday, very early doors, that was cancelled. The French ski resorts, I think, were one of the first to close down. And the tour operator said, oh, well, actually, we've incurred loads of costs. This holiday is about £4,000, £5,000. I said, we've incurred £70,000. So there's no way we could process a refund. I think they were applying it to all of their packages that they had at the time, which is quite unusual. But again, obviously, and you can quite imagine the particularly for small tour operators who potentially have no way of knowing if they'll get the money back from the suppliers, how challenging that time must have been. So it was kind of a laugh, but thinking about it now, I'm like, my God, now they're in business. And a lot of responses we were getting from tour operators when we were pursuing these claims is, we have no money to pay you. Crack on, bring the claim, will be liquidated by the time that you get anywhere near a judgment. So it was tough, but you can understand. This actually is not a COVID case, and I'm looking at some colleagues from Traveller in the audience and thinking, I'm hoping to get this right. I'm sure to tell you otherwise if not, but I think it was with them. So in this case, the claimant had booked a Northwest Passage cruise with the defendant. Effectively, some friends had recommended it. They picked up the phone, booked it, had a brief itinerary basically sent through to them, and then a few weeks later or a later time, there was a detailed itinerary which was sent to them. And in advance of the cruise, the route had to be significantly changed because there was an anticipation that a block of sea ice would have melted, but in fact it hadn't. And essentially, it was the main part of the cruise. It was what they were there for. Many of the elements that they wanted to see, they couldn't see essentially. And the claimant issued a refund based on the fact that this detailed itinerary was sent out, but actually there were many elements of it which tour operators were unable to provide. And at first instance, it was dismissed because they looked at the kind of basic itinerary of the booking in terms of what that actually meant. That was the formation of the contract in the view of the judge. And the claimants actually, I think that's on the person, appealed, and they felt that actually it should be the detailed itinerary which was relied upon in terms of what they could expect to see on their holiday. And that was reversed, the decision was reversed, they found for the claimants, which is quite interesting. And even though the itinerary was provided after the initial booking in terms of the formation of the contract, the judge thought it was a significant term of the contract between C and D, and the change of the route was tantamount to a significant alteration. The issue, of course, with tour operators is, are they beholden to every single element of what they say they can provide? You know, you look at some of the brochures, you can go to any travel shop in Manchester today, there's also some wild claims in there about the kind of things that you might be able to get. And will they actually be there, or is some kind of I don't know, cutting up of what's available? It does become quite problematic in terms of what's said. And actually, what was quite interesting about something the High Court judge said is that it bears comparison with the change in the resort area. So it extends out quite far. Thinking about the Greek fire issue recently, tour operators may have been able to place people in a different area or a different island of Greece to deal with that issue. But would they then have been entitled to a total refund or a significant refund after they returned? And there was also kind of a question about whether the flicker of hope test was effectively dead, because there's a suggestion that if the claimants or the travellers had a reasonable possibility of there being an alteration, they might be entitled to a cancellation or a refund. Who knows whether it makes any difference or not? I guess it's thinking about ex equo and the judge's approach to package travel regulations in general. There's obviously this view that the obligations are considered very widely, whereas defences are considered very narrowly, and it seems that it could be a further bump for travellers. Now, I understand that an appeal has taken place, and I believe that it's been handed down tomorrow, so keep your eyes peeled. It could be quite interesting in terms of what it has to say. I did see something in Travel Weekly that suggested that some aspects have been overturned. Some aspect, I think the claimant has still got some of the compensation, but some of the issues of the contract have been overturned. I won't say any more about that because I don't know. And it's something to all look forward to, and maybe you can see our travel colleagues in the break, and I might be able to give you a little bit nod as to what's happening. Back to.
Great. Well, I'm just going to wrap up by looking at two EU cases or CJEU cases, just because they sort of provide quite helpful commentary on the aspects of the regulations that we've been looking at insofar as they're derived from the directive. They were both decided after the end of the implementation period, so not binding, but potentially persuasive if they are to your benefit. Both cases were handed down in 2023 and relate to the theme of this talk, which is the impact of the COVID pandemic on the travel industry. This first case deals with the traveller's entitlement to a price reduction where there's a lack of conformity in the package, which we looked at as being under 12.7 was it 12.7? No, it was 16.2 of the regulations. And the facts here were that a German traveller's package holiday in the Canaries just really went awry because of the COVID pandemic. The beaches were closed, a curfew was imposed, you had to stay in a hotel room unless he was getting food and water, and there was an early return, I think 5 days into the holiday. It was supposed to be 2 weeks. So he came back and he asked for a 70% price reduction from the organiser on the basis of the German equivalent to Regulation 16.2 in our regulations. And the holiday organiser in Germany denied the claim on the basis that, well, the cause of the lack of conformity was COVID, so not the organiser's fault, perhaps not envisaged by those drafting the directive, and also something of a general life risk for which they should not be responsible, and that's sort of a particular idea coming from German law. This got to the CJEU and they said to the travel organizer, no, absolutely not. That's just not how this works. It's an absolute entitlement to a price reduction on the basis of the regulations. The cause of the lack of conformity does not matter, and you cannot invoke force majeure where there's no particular force majeure provision. And in the regulation 2.6 only, or 16.2 says the only way you get out of a price reduction for a lack of conformity is if the lack of conformity is due to the traveller itself. And the court looked at the drafting of the provisions very closely, which is why we went through them in such painful detail at the start of this talk, because the differences in drafting were really important. Because if you want compensation for a lack of conformity, there is an escape clause for organisers if that lack of conformity was due to the unavoidable and extraordinary circumstances, but there's no such clause when you're talking about a price reduction, and that meant that there was obviously a clear intention there for that exception not to apply. So force majeure as a concept couldn't be invoked on top of the regulations and the force majeure sort of ideas that it already had within it, and you just weren't looking at the cause of the lack of conformity when seeing if the passengers were entitled to a reduction. However, the court did say that you can look at the cause of the lack of conformity when calculating the amount of the price reduction, which could be quite a significant concession. The idea being that if it's not the organiser's fault, the reduction might be less than it would be otherwise. So that's where the cause could potentially come in and be relevant. And obviously the amount of the reduction, it's only described in the regulations as being an appropriate reduction. So that's obviously kind of subject to a huge amount of uncertainty and potentially litigation. The second case. Oh God, I really wasn't keeping up with my slides there at all, but you can read them all later with fascination. Oh, sorry, I've clicked one. Oh, okay. Yeah, there we go, perfect. So the second case is about France adopting some legislation during the COVID pandemic to say that basically to kind of get rid of the issues that 14-day refund period were causing the travel industry, as Nathaniel discussed. And it extended that period to 18 months. And basically travel organisers could give you a voucher, which you could either use during an 18-month period. And if you hadn't used it at the end of 18 months, well, then you could get your cash refund. So obviously a huge extension of the time period that you have to wait for your refund. And France said that it should be allowed to do that because the pandemic went beyond what was envisaged when the directive was adopted. It's permissible to derogate from its terms on the basis of that. CJU said no to France. We're working really hard on that one. Thank you. Hit the ball out. You can't invoke force majeure to vary the force majeure in the provisions in the directive. So again, this idea that you can't inception force majeure into these directives is only what it is on the face of it. And the CJU also has some helpful commentary about this is a money refund, this is not a voucher, and this directive is all about consumer protection, and a money refund is the best way to protect the interests of the consumer. So vouchers are not acceptable. That said, there's obviously consumers can agree to receive a voucher if they want to, but they nonetheless have the right to a refund if they want it. So again, just kind of reiterating the high protection levels for the consumers as the CJU is sort of want to do. It's worth noting just on this that there has been that the Department for Trade and Business published a call for evidence in September 2023 about potential changes to the package travel regulations. And one of the areas that it talked about was this difficulty with refunds and the idea of extenuating circumstances. And sort of saying, you know, should there be allowances for when things like that happen and it's difficult? So very much a suggestion that flies in the face of what this judgment sort of holds. And it's just also worth noting that there is a domestic case that the consumer protection, what is the CMA called in real life? I don't know. the CMA, yeah, Competition and Markets Authority. They basically went and got a declaration against Truly Holdings, which was a package organizer that went insolvent by the time of these proceedings. So actually, all the consumers that it hadn't provided a refund to during COVID were able through another compensation scheme to get their compensation, the Travel Trust Association. But the CMA wanted a declaration that not providing refund within 14 days was a breach of the terms of the regulation. And the judgment there is very clear that this is a strict requirement, and went so far as to say, even if you don't have the bank details of those customers, you're still in breach if you haven't refunded them within 14 days. So a very strict interpretation, very much in line with those EU cases, very much different to what this call for evidence is talking about changing. But of course, it's possible that we'll be looking at the change of government in the next little while. So those kind of changes and the force behind them may be sort of withering as we speak. But just something to kind of keep an eye on for this particular area. But yes, that is it. Thank you. Oh, that's nice. I really added a thank you slide because we haven't done one. Goodness, so impolite. But yeah, thank you very much for listening.
Thank you so much.